Hello, smart people. I know you are also confused like I was about the political situation in Rajasthan after watching the political drama between Sachin Pilot, Ashok Gehlot, Speaker of State Legislature, High Court, and finally the Supreme Court. Lot of parties are involved, and it's actual chaos. To understand this situation, we will begin from understanding the Anti-Defection Law. Way back in 1774, Irish philosopher Edmund Burke said in his famous speech on representation, representative should think of what is good for the country and not just for his constituents. The recent political crisis in Rajasthan has again initiated the discussion on anti-defection law in India. There are many questions whose answers we should know to have a clear idea of political situation around us. In this video, we have tried to discuss about the background of anti-defection law in India and how it emerged. Further, what are the ground of disqualification and exceptions of the same. So, let's open the book. In Indian politics, Ayaram Gayaram phrase became popular after Haryana MLA Gayalal changed his party thrice within the same day in year 1967. This incident and some more similar incidents in that same period made this evident that defection is not good for Indian politics. The situation of defection brings massive instability in the political situation, and to curb the same, anti-defection law was passed in 1985. The anti-defection law is contained in 10th schedule of Indian Constitution, and it was enacted by Parliament through 52nd Constitution Amendment Act in the year 1985. It basically lays down the process by which legislator may be disqualified on the ground of defection by presiding officer of the legislature. Alright, so now let's talk about what are the grounds under the ambit of anti-defection law in India on which a legislator can be disqualified. These grounds are: first, if the legislator is a member of political party, then he can be disqualified if he voluntarily resign from his party or disobey the party leadership on a vote, or when he abstain from party's whip. Secondly, if the legislator has been elected as an independent member, then he would be disqualified if he joins a political party. And lastly, if the legislator is a nominated member and join any political party after the end of 6 months, then he can be disqualified. In case of defection, any member of House can petition the presiding officer of the legislature to disqualify the legislator or the legislators in fault under the 10th schedule. However, there are some exceptions to this. Firstly, the legislator may change their party without the risk of disqualification if a party merges with or into another party with 2/3 of its legislator. In such scenario, neither the member who decided to merge or nor the one who stay with the original party face disqualification. And secondly, any person elected as chairman or speaker can resign from his party without the fear of disqualification, and can rejoin the party when he vacates the post. Here, it is to be noted that anti-defection law applies to both parliament and state assemblies. Now the question arises that who is responsible for making rule to give effect to the provision of the 10th schedule? And the answer is presiding officer of the House. All such rule must be placed before the House for 30 days. The House may approve or modify or disapprove them. Further, he may direct that any willful contravention by any member of such rule may be dealt with in the same manner as a breach of privileges of the House. According to the rule made so, the presiding officer can take a defection case only when he receives a complaint from a member of the House. Before taking final decision, he must give the member a chance to submit his explanation. He may also refer the matter to Committee of Privileges for inquiry. Hence, defection has no immediate and automatic effect. So as of now, we have learned the history of anti-defection law, the criteria of disqualification and the exceptions to it, and the rule-making power. Now let's take a look at the evolution of anti-defection law. The 10th schedule of the Constitution is designed to prevent the evil or mischief of political defections motivated by the lure of office or material benefits or other similar considerations. It is intended to strengthen the fabric of Indian parliamentary democracy by curbing the unprincipled and unethical political defections. The Rajiv Gandhi, then Prime Minister, described it as the first step towards cleaning up the public life. Then Central Law Minister stated that the passing of 52nd Amendment Bill by a unanimous vote by both the houses of the Parliament was a proof, if any, of the maturity and the stability of Indian democracy. After discussing this much about anti-defection law, we must know the advantages of this law. These are: it provides greater stability in the body of politics by checking the propensity of the legislator to change the party. Secondly, it facilitates democratic realignment of the party in the legislature by way of merger of the parties. And the third point is, it reduces corruption at the political level as well as non-developmental expenditure incurred on irregular elections. And last, it gives for the first time a clear-cut constitutional recognition to the existence of political party. Earlier, political party are just a mindset of people, but now it has some constitutional existence also. Now let's look other way around, the criticism part. Though the anti-defection law been hailed as a bold step towards the cleaning of our political life and started as a new epoch in the political life of the country, it has revealed many lacunae in its operation and failed to prevent defection in toto. It came to be criticized on many grounds, and some of those grounds are: it does not make a differentiation between the dissent and defection. It curbs the legislator's right to dissent and freedom of concise. Other point is that its distinction between the individual defection and group defection is irrational. In another word, it banned only the retail defection and legalized the wholesale defection. Its one more criticism is that when an independent member joins a party, he is disqualified, while the nominated member joins a party, he is allowed to do. And lastly, its vesting of decision-making authority in the presiding officer is criticized on two grounds. Firstly, he may not exercise his authority in an impartial and objective manner due to the political exigencies. Secondly, he lacks the legal knowledge and experience to educate upon the cases. In fact, two speakers of the Lok Sabha, Rabi Rai in 1991 and Shiv Rai Patel in 1993, have themselves expressed doubt on their suitability to educate upon the cases related to defection. After realizing need to strengthen anti-defection law, Parliament brought 91st Amendment Act of 2003, after which a member of either house of the Parliament belonging to any political party who is disqualified on the ground of defection shall also be disqualified to be appointed as a minister and to hold any remunerative political post. Now we will discuss about the current political situation in Rajasthan. Please watch this video till end to have a clear picture of situation in Rajasthan. The current political situation has raised some major questions, and to better understand this whole situation, we should know the answer of the same. Here, first question which arises is, when this is a matter of defection, then how did it reach to High Court? Answer is, Sachin Pilot and 18 other members were given a disqualification notice by the Speaker, and their reply was asked by July 17th as per the provision of the Anti-Defection Law. Against this disqualification notice, Sachin Pilot with 18 MLA filed a petition in Rajasthan High Court with these arguments. Number one argument was that they had not defected or given up the membership of Congress party. They are only expressing dissent against the functioning of the Chief Minister by staying within the party. Further, they have argued that the intra-party dissent cannot be regarded as voluntarily giving up of party membership. Hence, Speaker had no
jurisdiction to issue disqualification notice. Second point which was made by Sachin Pilot and his MLAs was that it is further argued that Speaker is acting with malified intention because he only gave the time of 3 days to them to reply on the disqualification notice served to them when current legislative rule provide at least 7 days to provide for any reply. One more important point argued in petition is that the whip is only applicable to proceedings within the House. Hence, defiance of party's whip direction to attend the party meeting cannot be considered as ground for disqualification. And now, recently in the last order, Rajasthan High Court has ordered the status quo on the disqualification notice sent by the Speaker, which basically means so far all the Congress MLA are not disqualified and any proceeding would not undergo against. With this, the second question arises here is that why this case went to Supreme Court. So the Speaker of Rajasthan Legislative Assembly approached the apex court against the July 21 order of Rajasthan High Court, which stayed the disqualification proceedings against all the Congress MLAs along with Sachin Pilot. Speaker, in its plea to Supreme Court, cited that the Quixote-Holland case of 1992 and said that the disqualification proceeding before the Speaker under 10th schedule are proceeding of the legislature and as such cannot be interfered by the courts. And now the latest update is that Supreme Court in this matter has prepared 13 questions of law, which they will answer after due proceeding are done. Gentlemen, here are today's video ends. But before closing this video, I want to request you to kindly watch this video once again and take note of entire mind map, and I suggest you to personalize this mind map in your own way so that you will never forget this topic. And if you have any query, you are most welcome to comment down below. You can also give some feedback to improve my upcoming videos. Thank you. See you in next class. Till then, stay focused and stay safe.